Hey, good morning. So as my colleague rightly said, my name is Obapa Ichani Amadampa, and I'll be taking you on today's presentation titled The Rights and Protections Entitled to an Employee under the Labor Act. Okay, so as part of the firm's duty, we embark on a training or law clinic which aims on educating the general public. And for today's presentation, the title is Rights and Protections Entitled to an Employee. So the presentation is going to go based on these overviews. So we'll first talk about the Labor Act, the definition of an employer or an employee, the rights of an employee under the Act, the duties of the employee, and some general protections of an employee as stipulated under the Labor Act. So our first point is, in Ghana, everything we do is backed or protected by law. So it is for this reason that the Labor Act provides certain rules and regulations that comprehensively deals with areas such as labor law, employers, employee, and trade union. Also, the Act provides for an establishment of a National Labor Commission, amongst others. And when we go further to the presentation, we'll know why the Act provides for a National Labor Commission. So we'll first talk about the definition of an employer as stipulated under the Labor Act. So the Labor Act defines an employer as an individual, an organization, or a company which employs or hires the services of a person. So per the definition in the Act, an employer can be an individual, a person, a small business, an institution, or a company. So it doesn't have to be only a company, it can also be an individual as well. So with this being said, we move to the definition of an employee as given under the Labor Act. So the Labor Act defines an employee as a person who works for an individual, an organization, or a company, whether part-time or full-time basis, and receives a compensation for the services rendered in the form of a salary. So with this, there are two types. So we have an employer and an employee. So the employer is the one who engages the service of a person, and an employee is the one whose services is being engaged for the employment. So under the Act, there are certain rights and duties of an employee. And Section 10 talks about the rights of an employee in an employment contract. So I'll go through some of the rights as stipulated under the Act. So the first one we'll talk about is the right of an employee to work under a satisfactory, safe, and healthy condition. So under the Act, as an employee, you're entitled to work under a satisfactory, safe, and healthy condition. So the perfect scenario that comes to this is in this pandemic time, there's the employer is supposed to provide or make sure that there's a safe and healthy condition of working. So the employer is supposed to ensure that there are equipment such as maybe the medical packets, provision of masks, provision of sanitizer. Like the employer is supposed to safeguard that the working condition is safe and healthy for the employees to work on. Also, they are supposed to in place like a shift system as the president announced. So they are supposed to be maybe 2-week shifts so that too many people are not crowded at the same place. So the second right I'll talk about is the right for equal pay for equal work done without distinction. So what I'll say about this is that it's under the law that the workers should be paid equally for the same services rendered. So that means if two people render the same job, it's under the law, they are both supposed to be paid equally. So maybe you can't pay a peer 100 cedis and another person 50 cedis for the same work which they've done. So under the law, they are both entitled to be paid equally. So we move to the third right, which is the right of rest, leisure, and reasonable limitation of working hours and period of holidays with pay as well as remuneration for public holidays. So under the law, an employee is entitled to rest and leisure. So maybe when you come to work, you're entitled to certain rest and leisure, such as lunchtime, maybe an hour for lunch. And when it's public holidays, you are supposed to stay home. You're not supposed to come to work. Your employer cannot mandate you to come to work for holidays. And you're supposed to be paid remuneration for the public holidays. So maybe an example is the Easter holidays, which is like 2 days, Friday and Monday. So employer cannot force you to come to work because under the law, you are required to enjoy those holidays and you're supposed to be paid for the holidays you've enjoyed. So another right of an employee under the Act is the right to form or join a trade union. As we all know, trade unions are basically collective organizations that work for the benefits of their members. So as an employee, it's your right to form or join a trade union, which would work for the benefits of your rights as an employee. Also, under the Labor Act, it's your right as an employee to be trained and retrained for the development of his or her skills. So under the Act, your employer is supposed to organize training seminars or train you as at when the need arises, so you become up to date and your skill improves. Also, lastly, you are supposed to receive information relevant to your work as an employee. So where an employer hires you, you're supposed to receive information on what you are required to do as an employee. They just can't leave you without any information or providing any information relevant to your lawful occupation. So talking about the rights, we know that rights and duties go hand in hand. So there's the rights, also there has to be a duty of an employee. So the Labor Act provides the duty of an employee in an employment as follows. So we are going to talk about a couple of duties the law imposes on us as an employee. So the first one we'll talk about is the duty of an employee to work conscientiously in their lawful chosen occupation. So what this basically means is, as an employee, you're supposed to be diligent in your area of work. You're supposed to be dutiful, committed in your chosen area. So you can't just go to work anytime you like or do anything. Under the law, you are supposed to be dutiful and committed to whatever you are choosing to do. Another duty the law imposes on us is to report for work regularly and punctually. So as an employee, when your contract of employment states that you're supposed to come to work 8 to 5 and be present for 5 days a week, under the law, you are mandated to come for those periods. You're supposed to be at work before 8 and close at 5. But say for some special circumstances, the law mandates you to come to work regularly and punctually. So if you're supposed to come from Monday to Friday, unless maybe something serious happens, you're supposed, under the law, come to work for those days. Also, another duty the law puts on the employee is to enhance productivity. So as an employee, it's your duty to enhance the productivity of whatever occupation you've been hired to do. So an example is you have to be an asset to the employee. So you have to be creative thinking, you have to do research, you have to be adding up to the productivity of the work. You should be an asset to the worker, not just come to work and just get paid. So under the law, you are mandated to enhance productivity. So the other thing I'll talk about is exercise of due care in the execution of assigned work. So under the law, you are obligated to exercise due care in the execution of the assigned work. So what this basically means is that under the law, whatever you have been assigned to do, you're supposed to exercise due care. So maybe if you are assigned to, maybe you're a janitor, you're supposed to clean the place, you're supposed to do it in the way that you've exercised due care, don't just do it anyhow. So you just exercise due care in whatever you've been assigned to do. Also, another duty the law places on employees is the duty to obey lawful instructions regarding the organization and the execution of his or her work. So under the law, you are supposed to obey lawful instructions. So mind you, the law adds lawful instructions. So if the instructions you've been given is lawful and is required, legally required for your field of employment, the law mandates you to lawfully obey those instructions. Another thing I'll talk about is the duty to take reasonable care for the safety of health of your fellow workers. So under the law, it's your duty to ensure that reasonable care is taken for the safety and health of your fellow workers. So an example would be during the pandemic. If you maybe you go test, you contracted the COVID, under the law, you are supposed to stay at home so you don't come to work and put the life or the health of your fellow workers in danger. The law also makes it a duty of an employee to protect the interests of the employer. So under the law, you're supposed to protect the interests of your employer. So a classic example would be maybe in your area of work, the AC is on, electricity is on, the taps are flowing. Under the law, you are mandated to ensure that you turn off the AC when we are not using it, when the taps are flowing, because the more it keeps running, the more you give your employers, like the bills, the electric bills would rise, the water bills would rise. So under the law, you are under the duty to protect the interests of the employer. So the other duty I'll talk about is the duty to take proper care of the properties of the employer has entrusted to you. So under this, you are supposed to, whenever in the course of your employment, where the employer gives you property such as a car, a phone, laptop, under the law, you are mandated to take proper care of the property. And you're not supposed to treat it anyhow just because it doesn't belong to you, and probably after your employment, you would leave it with the employer. The law mandates you to take proper care of the property entrusted in your hands as an employee of the company or wherever you are working. Okay. So in addition to the interests of your employer, you have to make sure you don't act in a manner that promotes the interests of your employer's competition. So what this basically means is that in the course of your employment, you shouldn't act in a way, or you shouldn't promote your employer's competition, because as you do that, it acts to the detriment of your employer, and your employer's income or profits will reduce drastically as a result of your actions. So the law mandates us not to do anything that promotes the interests of your employer's competition. So aside the basic rights and duties provided under the Labor Act, there are other protections and conditions which do not particularly fall under the rights and duties of an employer, but they are just general provisions that the law states in the Act that protects us in the course of an employment. So we talk about, so some of these include contracts of employment, leave, termination, and so on. So we'll talk about contract of employment as a right to an employee. So the first one is contract of employment, which is stated under section 12 and 13 of the Labor Act. So under the Labor Act, an employee is entitled to a contract of employment where the employer engages the services of the employee for a period of 6 months or more. And what this basically means is that where the employer seeks to engage your services for a period of 6 months or more, you're entitled to a written contract which clearly spells out the obligations of both parties, what entails in the conditions of employment and everything. And the law states that you're entitled to this within 2 months after the commencement of the employment. So what this basically means is that an employer cannot contract you for a period of 6 months or more without giving you a written contract of employment. So you can't just be going with no binding contract of employment given to you. So the next protection I'll talk about is some prohibition the law states on restrictive conditions of service. What this basically means is that the Act prohibits inclusion of certain restrictive conditions of employment in employee's contract of employment. So I'll be talking about a few of such restrictions the law frowns on. So the first one I'll talk about is a condition which restricts an employee from participating or refraining from participating in the lawful activities of a trade union. So what this basically means is that an employer cannot, as a condition of employment, restrain you from participating in the lawful activities of a trade union. When the employer includes such a clause in your condition of employment, the law says that the employer cannot do that. Also, the employer cannot refuse to employ you because of your membership of a trade union. So what this basically means is that the employer cannot refuse employment because you are part of a trade union, because we all know that what trade unions do are there. It's a collective organization that fights for the welfare of their members in a labor environment. So the employer cannot refuse to employ you based on your membership of a trade union. So we'll talk about the next point, which says that an employer cannot promise an employment benefit or an advantage for not participating in trade union activities. So it follows the first one I just said, that as an employee, the Act gives you a right to join a trade union. So an employer cannot refuse or promise you an advantage or a benefit for not participating in a trade union, because it's your right as an employee to participate in the activities of a trade union. So the next one I'll talk about is discrimination against an employee, grounds of gender, race, color, ethnic origin, religion, creed, social or economic status, disabilities or politics. And this provision in the Act goes on to affirm Article 19 of the 1992 Constitution, which states that a person which provides for freedom of against discrimination. So this provision in the Act affirms that employer cannot discriminate against you on the grounds of whether gender, race, color, ethnic origin. Like, the law prohibits such restrictions, your conditions of employment. So the next thing we'll talk about is leave. As an employee, your entitlement to leave. So this is stated under Section 20 of the Labor Act. The first provision is that in an employment, an employee shall be entitled to not less than 15 working days of leave with full day in a calendar year of continuous service. What this basically means that in a given year, as an employee, you're entitled to not less than 15 working days. So it becomes illegal if your employer does not give you the 15 or more days that you are required to enjoy under the law. Also, the law provides certain interruptions with work, such as sick leave, public holidays, or even absence with permission. And those days shall not be counted or calculated as part of the 15 days you're entitled to or more. So you can't, so what this basically means is that maybe when you are sick and you have to stay home during public holidays, and even with absence with permission, the employer cannot deduct those days and say that even though you're entitled to not less than 15 days, these days were absent, so I'm going to deduct these days from your leave, which is not less than 15 days. What this provision basically says is that the employer cannot do that. Another thing is the employer, in the case of a woman, you're entitled to maternity leave, that's 3 months. So the employer cannot say that maybe because you were pregnant and you were given 3 months of maternity leave, during the year, the calendar year, you won't go for your leave. That maternity leave is a special leave on its own. So as a woman, you're entitled to your 3 months maternity leave and an additional 15 or more days of leave as provided in the Section 20 of the Labor Act. And also with the leave, the employer decides on when the employer should go on the leave based on the best interest of the organization. What this basically means is that the employer has the power to decide on when you go for it. So maybe when the company is at its peak or production is going up, you can't say you are choosing that time to go for the leave. The employer has the power to determine the days you take. Just that the day shouldn't be less than 15 working days. So the next thing we'll talk about as a general protection or condition of employment is hours of work and overtime. So section 33 and 35 of the Act deals with the hours of work and overtime. So the Act provides that an employee or a worker shall have a maximum of 8 hours a day or 40 hours a week, except with the exception of some cases expressly provided for in the Act. So what this basically means is that as an employee or a worker for an organization, you have to work at the maximum of 8 hours a day and 40 hours a week. So any other additional hours shall be regarded as overtime. So when they are supposed to, and the normal 8 to 5, so when they're supposed to come 8 to 5, those are the lawful working hours provided under the Act per section 33 and 35 of the Labor Act. Any other extra hour you do should be regarded as overtime. So what this basically means is that when your employer requires you to work beyond the 8 hours stipulated under the Act, it becomes an overtime, and the employer is supposed to pay you for those extra time. So in the agreement, there should be fixed rates to pay for overtime, so that when you do those overtime periods, the employer has to pay you the agreed rates. Also, the Act also further states that the worker shall not be compelled to do overtime work except for undertaking or enterprises where the very nature requires overtime in order to be viable, or where the emergencies require workers to engage in overtime. So as a general condition, you are supposed to work within the 8 hours as provided in the Labor Act, but the Act also further goes on to state that in some exceptions, undertakings of overtime may be allowed, and the exceptions they give is where the very nature requires overtime in order to be viable, or the work is subject to certain emergencies that require the worker. So maybe when you are a doctor or something and there's an emergency, maybe your employer can call you because the very nature of your work requires that you do certain overtime. So also, in other companies would also require, there are some instances where maybe goods have arrived, they need you to come and clear it. You don't have like a time or a right over, you don't determine the time they come. So in such companies where maybe goods arrive, maybe they might call you to do an overtime. Such instances, the law provides for them, and you shall be paid in accordance with the agreed fixed rate for overtime. So we'll talk about grounds for termination of unemployment as stated under the Act. Section 15 of the Labor Act gives the various grounds in which there can be termination of a contract of employment. So the first ground the Act gives is by a mutual agreement between the employer and the worker. So what this basically means is that there can be a mutual agreement, and it can be for so many reasons, reasonable reasons. Maybe you want to relocate outside the country, maybe you've gotten admission to school, you want to further your education. So there are various reasonable reasons why a worker might want to end the employment. So that one, by mutual agreement between both the employer and the worker, they can come to a mutual agreement to terminate the employment. Another way, as provided under the Act, is on grounds of ill treatment and sexual harassment. So what this basically states is that where you find yourself in the working environment, if you feel you are being ill-treated or maltreated, you can use that as a ground to end your employment contract. Or also where you feel you are being sexually harassed at the place of your employment, you can base on that as a ground for termination of the employment. Another way, as provided by the Act, is where the death of the worker before, where there's the death of the worker before the expiration of the period of employment. So what this basically means is that where maybe there's a contract of employment for 7 years, and after 3 years, the employee dies, it serves as a ground for termination because automatically the employment has come to an end due to the death of the worker. So another ground is where the worker is found on medical examinations to be unfit for the employment. So an example is maybe where a company employs you to be a driver, and due to some illness or injury, maybe you're amputated or you can't walk, definitely, then automatically you can't do what you are employed to do. So the employment, or it can serve as a ground for termination of the employment. So under the Act, there are 2 categories of termination of employment. So the first one is fair termination, and the second one is unfair termination. So for the purpose of this presentation, I'll talk about both fair and unfair termination and the various remedies as provided under the Act. So the Labor Act states that a termination of a worker's employment is fair if the contract of employment is terminated by the worker on the following grounds. So what this basically means that under the law, specifically the labor law, where the termination of the employment is based on the grounds I'll be talking about, then the termination is deemed to be fair. So the first one the Act states is where the worker is incompetent or lacks qualification in relation to the work for which the worker is employed. So where we are employed to do something and you are incompetent, you lack the qualification, you can't do what you're supposed to do, then automatically it serves as a fair termination, a fair ground for termination, because you can't do what you've been employed, or you're incompetent to do what your contract of employment states you to do. So the second ground, which the law classifies as fair termination, is where there's a proven misconduct of the worker. So most organizations and companies have rules and procedures which you have to do. So mostly it's stated in your contract of agreement. So where the worker goes contrary to a stated rule in the company or under your contract of employment, then automatically it becomes a ground for fair termination of the worker's employment contracts. Also, another mode of fair termination is redundancy under Section 65 of the Labor Act. So we'll talk about that one later. And also the last one is due to legal restrictions imposed on the worker, prohibiting the worker from performing the work for which the worker is employed. So what this basically means is that where maybe you commit a crime and you are, during the course of your employment, you commit a crime and you are put under maybe house arrest or you are imprisoned, then automatically you can't continue with the employment. So where the employer terminates the agreement with you, then it becomes a fair termination, because you can't, by way of legal restrictions, continue with what you were employed to do under the employment agreement. So these 4 constitute the various ways in which an employment contract can be fairly terminated. The first one is the incompetency or lack of qualification of the worker. The second one is through a proven misconduct of the worker. The third one is through redundancy. And the last one is due to legal restrictions imposed on the worker. So now that we've talked about the various fair means of terminating a contract, we'll talk about the unfair means of termination of the contract. So this is provided for under Section 63 of the Labor Act. So Section 63 gives the various categories which makes a termination of a contract of employment unfair. So we are going to go through the various means which termination of an employment becomes an unfair. So the first one is, and mind you, the Act says that the termination becomes unfair if the termination is based on only the reasons stated below. So maybe if there are other reasons for fair termination, it can form as a ground for termination, but the reasons of termination has to be only the ones stated in the act. Then it makes the termination unfair. So the first one we'll talk about is termination of an employment based on the reason that the worker has joined, intends to join, or has ceased to be a member of a trade union. So what this basically means is that where an employer terminates your employment because you have joined a trade union or you intend to join the trade union, or maybe you were a member of a trade union and you've ceased to be a member, then the act states that that termination is unfair. Also, another way in which a termination of employment will be deemed unfair is where the worker seeks office or is acting or has acted in the capacity of a workers' representative. So what this basically means is that where in an employment, the worker seeks office as maybe the secretary, the treasurer of a trade union, or has acted in the capacity of a workers' representative in maybe a topic that has come up in a trade union. And based on that, the employer terminates the employee's employment contract, then that would be deemed as an unfair termination. Also, where the employment contract.
What are you trying to say?
Okay.
Who told you both is 7 cedi?
Sorry. Is what you say?
I can send him a WhatsApp for his email address.
Please, can you? Yeah. So, sorry for the corruption. Also, another way in which the termination of an employment will be deemed as unfair is where the contract is terminated because the worker has filed a complaint or participated in proceedings against the employer involving alleged violation of this act or any other enactment. So what this basically means is that maybe when your employer does something that's against the act or any other act, and you file a legal complaint against your employer, or you participate in a proceeding against your employer. So an example is maybe if the employer has engaged in a misconduct and as you are an eyewitness and you participate in the proceedings against the employer, giving your truth, the employer cannot base on that and terminate your contract of employment. When the worker does that, when the employer does that, it will be deemed as an unfair termination of your employment contract. Also, as stated earlier, and as stated in Article 19 of the Constitution, the employer cannot terminate your employment contract based on your gender, race, color, ethnicity, origin, etc. That constitutes discrimination, which the law founds on. So the termination of your contract based on that will be deemed as an unfair termination. The law also makes provision for termination of a contract in case of a woman due to the pregnancy of the woman or the absence of the worker from work during maternity leave. So where in the case of a woman, your employer terminates your contract because you are pregnant and maybe become slow as a result of the pregnancy, or during the legal absence of maternity leave, which is 3 months, you come back and your employer has terminated your maternity leave, it becomes an unfair termination because under the law, you are given the right to go for 3 months maternity leave, and the employer cannot base on that to terminate your employment contracts. So the last one is, the last but not the least is because of disability, where due to the worker's disability. So when you are employed with a disability, your employer cannot go back and terminate your contract of employment based on the disability. And the last one we talk about is based on a temporary illness or injury that is satisfied by a recognized medical practitioner. So we are human and anything can happen. So maybe during the course of the contract of employment, where you get temporarily ill or injured, and maybe due to that, you can't come to work for some time, the employer cannot base on that to terminate your employment contract. So with this being discussed, we'll talk about the various remedies provided under the Act for unfair termination of employment contracts. So under the Act, specifically Section 64 of the Act, it states the remedy of unfair termination. So where a worker claims that his or her contract or employment contract has been unfairly terminated, the worker has to first file a complaint at the Labour Commission. So if you remember at the beginning, I told you the Act makes provision for the establishment of a Labour Commission. So these are some of the reasons why, or the functions of the Labour Commissions. That's how come they were established under the Act. So the worker would first present a complaint to the Labour Commission. And if upon investigation of the complaint, the commission finds out that the termination of the employee was unfair, the commission may order any of the following. So the first thing the commission may order to the employer is for the employer to reinstate the worker from the date of termination of employment. So this kind of has a retrospective effect. So where upon conclusion of the investigation, the Labour Commission finds out that the termination as complained or filed by the worker is unfair, it can order the employer to reinstate the worker. So this would start from maybe where your employment was terminated in January, the Labour Commission will ask you to be reinstated as at the time of the termination of the employment. So the second thing the Labour Commission may order the employer to do is to re-employ the worker in the work which the worker is employed before termination, or other suitable work on the terms and the conditions enjoyed by the worker before termination. What this basically means is it starts from when they come to the conclusion that the employment was unfairly terminated. So with this, they'll order your employer to re-employ you for the same position in which you were enjoying, or a similar position with the same conditions and terms of employment. Or the Labour Commission may order the employer to pay compensation to you. So these are any of the three things the Labour Commission can order your employer to do when, after an investigation, it's concluded that your termination was unfair. So we'll go on and talk about notice of termination. So the Act under Section 17 gives the various means or ways your notice of termination should be given. So in the case of a contract of 3 years or more, you are required to be given 1 month notice or 1 month's pay in place of notice. So that means where your contract is for 3 years or more, your employer has to give you 1 month's notice. Also, in the scenario where, or in the case where your contract is less than 3 years, the law states that the employer has to give you 2 weeks notice or 2 weeks pay in place of notice. And in the case where the employment is from week to week, 7 days notice will suffice. So the next topic we'll talk about is disciplinary hearing. So this is a common law principle which states that you're entitled to be heard before your employment is terminated. So we talked about the various fair means of termination. So in the situation before you be given your notice, you are entitled to a disciplinary hearing. You're entitled to a disciplinary hearing. So they're supposed to set a panel. They're supposed to be told in no uncertain terms the reasons why your contract is to be terminated. And you are entitled by law to provide responses to the reasons indicated for your dismissal. You are also entitled to appear before the committee either by yourself or by a lawyer. So failure by the employer to go through this would render, in the circumstances, might form grounds of unfair termination. So what this basically means is that before your employment is terminated, you have to be heard. So you have to be told the reasons why your contract is to be terminated, and you're supposed to be given time to respond to the allegations against you or the reasons stated why they intend to terminate your employment. And you have to appear to give this either by yourself or with a lawyer. So under the law, you can do that. So failure of the employer to abide by these rules will render the termination as unfair. So we'll talk about redundancy as provided under Section 65 of the Labor Act. So the redundancy is a term of art. So redundancy basically means when an employer reduces their workforce because a job or jobs are no longer needed, or because the employer is going through some financial difficulties, which would warrant the need to make some structural adjustments in the organization, in the organizational structure. However, the law provides strict guidelines to be followed before an employee may be made redundant. So it goes without saying that failure by the employer to follow or abide by the regulations may lead to the redundancy being declared as unfair. So the various guidelines the employer is supposed to go through is found in Section 65 of the Labor Act. So it includes, some of the guidelines includes the employer providing in writing to the Labor Commission and to the trade union no later than 3 months before the contemplated changes is ensured. Also, the employer has to confer with the employee in question. And after everything has been settled, the employer has to pay the employee a fair severance package, which must be fairly computed with the increase of the employee consent. So what this basically means is that maybe in this pandemic, take the aviation industry for example, most planes were grounded. So the positions of a pilot, flight attendant, there was no use because no planes were flying. So with this, their position or their role became redundant. Their services were no longer needed. So by the law, you have to go through some procedure, and this is a lawful ground of termination or a lawful end of a person's employment. So you have to go through the guidelines as provided under the Act to make the redundancy a fair one. So failure to do that, the redundancy becomes or may be termed as unfair. So the next thing we'll talk about is remuneration upon termination. So after all the procedures have been gone through and the employment of a person has been successfully or fairly terminated, the law makes provision for payment or remuneration of certain monies earned by the employee upon termination. So we'll go through some various provisions by the law. So the first one is the remuneration earned by the worker before a termination. So what this basically means that upon termination, if maybe you've worked for the period of May and your employment is being terminated at the end, you've earned your salary for May. So the employer is under an obligation to pay you your salary as you earned it. Also, any deferred payment to the worker before termination, the law requires that you pay the employee before upon termination, or what you owe. Maybe if you owe the employer some allowances, some packages, some deferred payments, the law states that the employer is supposed to pay the employee all the deferred payments before termination. Also, in the case of termination based on sickness or accident of the employee, the law mandates the employer to pay compensation to the worker who is sick or because of an accident cannot continue its employment contract. Thank you. So these are the various rights, duties, and protection as stated under the Labor Act. So we have questions and answers. So please, for the question and answer session, a colleague of mine will take and give the answers to any questions which you may have. Thank you so much for your time. Thank you.
Hello, good morning once again. My name is Nana Kofi. I'm here to take some of the questions that have been put out while the presentation was being done by my colleague. So what I can see first is an employee permitted to repair an asset on his or her own volition in the event that it gets spoiled. So strictly speaking, it is not the duty of an employee to repair an instrument, equipment, or whatever of such nature that he's using in the course of the employment when it gets broken. Strictly speaking, saying the law does not impose that obligation on the employee, but sometimes in practice, it becomes necessary for the employee to take the initiative to do it. It doesn't mean it's an obligation. It's just that it's practical. Now, in instances where it has become practical for the employee to repair the said instrument or asset or whatever on his own volition, then he is entitled to the amount of money he used to repair that equipment. Unless it can be proven that that equipment was spoiled due to the negligence or recklessness of the employee concerned. So if the equipment is being used in the normal course of business, for instance, you are a driver, you are supposed to go and deliver goods from Accra to Kumasi, and through no fault of yours, the vehicle gets broken down. You are not under an obligation to pay for its repairs. However, if, for instance, the contract is supposed to be performed under a certain period of time, and the vehicle breaks down and you are in a position to have it repaired so you continue the delivery, you are entitled to be reimbursed for the amount of money that you used to repair the vehicle. However, if on your way to Kumasi, you decide to take a detour and go and do or engage in a business of your own, which has nothing to do with what you are supposed to do, then you shall pay for the repairing of that vehicle at your own cost. Please, if for any reason the answers we are providing are not giving clarity enough, you may do so and then we will come back to that particular question. And we also aim to make it as interactive as possible. So whoever's question we are answering, if the answer does not provide clarity, the person can just speak up and then I'll quickly address before I move on to the next question. So having dealt with that, the next one I can say is from Philip Bonsi. He wants to know the implications of not being given a written agreement. So first, we need to understand the import of the written contract. It is the contract of employment which spells out every single obligation and entitlement and duties of the employee. So for instance, if there is no contract of employment and I am suspended or I am fired or I am sacked for engaging in insubordination, the question then comes that I can challenge my suspension because I have not been told what amounts to insubordination, which means that I can challenge the legality of my dismissal because when I was employed, I was not told that doing ABCD is an illegality. So the contract of employment is what guides the relationship between the employer and the employee. If I am being engaged to work 9 to 5, it has to be stated in the contract of employment. If there is no contract of employment and I decide to close at 3, you cannot hold me accountable because you have not given me a contract of employment stipulating exactly my closing days and my closing periods. So in effect, without the contract of employment, using the layman's language, the employment relationship becomes invalid in certain circumstances because it is the contract of employment that gives the relationship the legality it deserves, which does not mean that if a worker has been working for an employer for a number of years without a contract, it doesn't mean the worker is not entitled to any benefits. In that instance, the law provides the worker more than the employer. Without the contract of employment, the law looks more favorable on the rights of the employee, my mistake, as against the rights of the employer. So it's imperative that in any contractual agreement that's to do with employment, there is a contract. It doesn't have to be any cumbersome contract. It can be a one-page spelling out clearly the duties, the time, and how much the person is supposed to earn. The next question is from LGI regarding the legal guidelines. Regarding the legal guidelines that's to do with reassignments, LGI wants to know whether the employer can change the employee's job description at will. The immediate answer is no. A person is engaged to perform a certain act, and it was based on his qualifications that he was employed to do that particular act. However, it's also recognized that the employer or the company might be going through some difficulties which might necessitate the worker taking on additional roles, or which might necessitate that the worker's duties will be varied. The caveat here is that the employer has to inform the employee of the decision to vary his duties, and the employee is under no obligation to agree. However, if the employee being under no obligation to agree, the employer may also have the right to make that position redundant because it is not serving the interest of the organization. So it all has to do with balances. You as the employee or the worker, you are under no obligation to consent to your duties being varied. However, in the interest of the organization, and the variation must not be to your disadvantage. So if you were engaged to perform a role, and let's say you are earning 2,000 cedis, your employer does not have the right to vary that role and give you a role where you will be earning less than the 2,000 cedis. That variation is not allowed. If your role is being varied, then you must earn exactly the same amount as what you were employed to do, unless it has to do with a matter of redundancy or restructuring due to financial difficulties that the employer is going through. So if the employer can no longer afford to pay you what he engaged you, then he must sit down with you, and then you must also agree to your salary being varied. Then we go on to the rights of the employees to privacy at the workplace. The Constitution, being the supreme law of the land, provides that every person, whether employee or employer, is entitled to an amount of privacy. However, it is not a right that does not come with a certain amount of limitations. So your right is not an absolute right, in the sense that if that right infringes upon the right of another person, and in this regard, a company can be said to be a person. So you have a right to do A. However, if that right is inimical or it goes against the interest of the company or organization, then the organization has the right to place certain limitations on that right. So an example, in a bank, for security reasons, the bank has the right to install cameras in the banking hall. However, the bank does not have a right to install cameras in places of convenience, for example. It will be an invasion of the privacy of the employees if the places of convenience, washrooms, and the rest have cameras installed there. So the right to privacy when it comes to the workplace is not absolute, because the employer also has the right to protect the assets of the organization, and also to make sure that the employees are engaging in the acts for which they were employed. Another example is the blockage of certain websites when you go to certain organizations. In certain organizations, you can access the internet only for things that you were employed to do. That is not an infringement on your right. It is the right of the employer to protect his workplace and the resources of the organization. So in that regard, the right to privacy at the workplace is not an absolute right. It is always subjected to the interest of the employer in protecting assets and other properties belonging to the organization. We then move on to a question from Naliban Wujangi. He wants to know what happens when an employee does not return after his or her leave. Ordinarily, the answer will be that will amount to an automatic termination of their agreement. However, because the law recognizes that we are dealing with human beings, the practical thing to do in that regard will be for the employer or the organization to find out the reason why the employee has not returned from the leave. And that can be done through a written request, a simple written request informing the employee that the leave has ended and you were supposed to return on this date and you have not returned. Why have you not returned? In certain instances, depending on the nature of the employment, he or she might even be given a certain date for him to appear or to show up at work. After all of this, the employer has the right in this regard to terminate the appointment of the employee without having the need to give him any hearing, as my colleague mentioned earlier on, because the letter or the inquiry to the employee will serve as a hearing. You went for leave for 1 week. You were supposed to return on the 25th of May. We are on the 28th of May and you have not returned and you have not provided any reasons. Can you please explain why? Or the organization is giving you a week for you to return to your post, failing which your contract shall be terminated. That will serve as enough notice to the employee. So the answer is that any employee who does not return at the end of his or her stipulated leave, the employer is entitled to terminate that contract. But in practice, it is fair and it is proper for the employee to first find out the reasons why, for the employer to find out the reasons why the employee did not show up after the end period, after which the contract may be terminated without giving the employee any reasons for the termination. Do I sense someone wanting to do a follow-up?
Can I just ask a question?
Yes,
in addition to just a follow-up.
Okay.
So the reason why I asked that question is that a friend of mine, staff, claimed that he had some leave.
Mm-hmm. He claimed
that yes, he claimed that because I say he claimed because I don't know I'm not within the organization. So
okay, so let's assume he was entitled to the leave and then he went on leave.
Yes, he's entitled to the leave.
Mm-hmm.
Let's say he said it was 2 years accumulated leave, and he says that he wants to take the full leave, but the employer said that because of the role that he has, he cannot go on the full leave. So the employer proposed a timeline for him to take the first one, come back for some time to ensure that to enable them do some work, and then he can go back on the leave. But the employee, through letter, insists that he's going to come on the day that he wants to come. Then the employer, he says he's written back to the guy, but the guy has not shown back up at work till now, even though the time that the employer gave them has elapsed.
Okay, but the accumulated leave period has not lapsed.
The accumulated leave period has not elapsed.
Yes. So you see, it presents a conundrum. That is where the employment contract becomes very, very necessary, because in a model contract of employment, all of these things are stated there. That yes, you are entitled to this period of leave. However, and my Obapa mentioned it briefly. However, the employer reserves the right to decide when you will take that leave. So you can put in a request that, oh, I'm entitled to 21 days, so I want to take the leave now. The employer can say that, oh, yes, you are entitled to that leave. However, due to the nature of your work or because of what we are going through now, please defer your leave and take it next month. Okay, that is one. Now, two, the leave having accumulated, the employee is entitled to all that accumulated leave. He is entitled to it. However, in practice again, based on the interest of the employer or the interest of the organization, especially when it has to do with the survival or it has to do with the productivity of the organization, a discussion can be had with the employee for the employee to agree to vary. So in this regard, the employer is within the confines of the law by requesting to the employee that, okay, I appreciate that you are entitled to this amount of leave, but because the organization is going through this difficulty and we cannot afford for you to do A, B, C, D, please let's vary it and then take this amount of leave instead of that. But it also behoves on the employer to make that proposal attractive. So offer monetary compensation that, oh, you are supposed to take 2 years, but please, we are going through this difficulty. Can you take 1 year with the promise that, oh, you will get this and this and that for you to forego that leave? So now where we are is that the employee is right to insist that he has 2 years accumulated leave. The employer is also right to say that my organization is going through challenges. I cannot give you that 2 years. Let's agree for you to take 1 year out of the 2 years. If there was a contract of employment and it was stipulated there and the employee had signed, then the employer will have the higher authority to even fire, because it was in your contract and you have signed. So now you cannot say that you will not go by it. In the absence of the contract, it becomes a matter of conscience. Now, if the employer sees that the continuous absence of the employee is detrimental to the organization, like what is happening now, the employer may terminate the contract of the employee on the grounds that your continuous absence is causing me to lose so and so and so, and I have to engage somebody in your stead. But you also have to bear in mind that the employee may also decide to take this matter up in the courts. And in that regard, the courts will take a balance of interests, the interest of the organization and the interest of the employee. In practice, most instances, the interest of the organization prevails because there are other employees in that organization who are also earning income from the survival of the organization. So the whole thing becomes simplified where there is a contract of employment and it is indicated there clearly that your leave may be varied due to the best interest of the employer or the organization. So in practice, I will not be able to answer your friend's inquiry unless he comes to pay consultation and then he becomes our client. Are we clear enough? Hello?
Yes, please. Thank you very much.
Okay, can I move on to the next question then? Okay. Okay, so the next question is the next question has to do with indefinite. The next question has to do with the position of the law concerning indefinite suspension. No employer has the right to place any employee on an indefinite suspension. There always has to be a provision that you are being suspended for so and so periods. And you need to indicate to them the reasons why they are being suspended. And the suspension has to be within a reasonable time. The suspension has to be within a reasonable time. In most instances, the indefinite suspension is done, one, either for investigations to be done or as a disciplinary procedure. If it is being used because the employee has committed an act and the employer does not want to the employer does not want to dismiss the employee or does not want to terminate the agreement, but rather wants to suspend the employee for a period of time, then it has to be for a stated period of time. It will be deemed to be onerous for the employer to say, oh, I'm suspending you indefinitely because you have done A, and I will call you back at my own convenience. No, the law frowns on that. So if you have any intentions of suspending any employee, either to conduct investigations or as a disciplinary measure, then it has to be for a stated period of time. Now, to add, where the suspension is being done as a means or for certain investigations to be done, then in some instances, the employee will even be entitled to half of his salary during the period of the suspension. So if someone has committed an act, you are suspending him so you can investigate the act that he has allegedly committed. If you are suspending him for 1 month, he will be entitled to 2 weeks pay. However, if after the suspension, the investigation turns out that the employee was innocent of all the charges, then the employee will be entitled to the full pay during the periods under which he was under suspension. If the investigation turns out that the employee was guilty of the act, then the employer has the right to deduct the amount of money paid to the employee during the suspension from the compensation or from the severance package that will be paid to the employee. So no, the law does not allow the employer to suspend any employee indefinitely for any offense whatsoever.
Clean your lips. I don't know what you're eating.
Okay, so my MC informs me with our time constraints, I can only attend to 2 more questions. The next one I see has to do with a question concerning paternity leave. Unfortunately, our laws are silent on paternity leave. Unlike the UK, where the labor laws stipulate clearly, and unlike some of the Scandinavian countries, where it is a clear stipulation that there is paternity leave, our laws are silent on that. However, that does not take away from the right of any employee or any organization to input that in their contract of employment, to give a certain amount of time for fathers to also spend with their freshly delivered wives and their infant babies. To be fair, and in practice, it even improves the productivity of the fathers concerned, because it has been proven that where there is peace of mind at home, it turns into increased productivity at the workplace. So we encourage as much as possible organizations and employers to also give paternity leave so that the familial relationship that society wants to uphold is strengthened. So no, our laws are silent on paternity leave, but we are hopeful. There is currently a draft labor bill before Parliament, which is being considered. The maternity leave has been proposed to be increased from 3 months to 6 months. And if that is approved, then it will be a requirement in the new labor law that the maternity leave will then be 6 months. Now, there is also a proposal for the inclusion of a paternity leave, but it will be subject to the debate in Parliament, and it will be subject to its approval. So no, our laws do not provide explicitly for paternity leave, but in practice, the law does not bar any organization or employer from granting paternity leave to their employees. The last question has to do with whether the failure to achieve results is a cause for termination. Once again, I will make reference to the contract of employment. Now, we have already indicated that the contract may be terminated where the employee either loses the qualification based on which he was employed. For example, a pilot losing his flying license, or a medical doctor losing the license to practice, or a lawyer, for whatever reason, losing his license. The employer has the right to terminate the agreement based on that. Also, and in practice, certain banks, that's why I said that's why the contract of employment becomes very necessary. If it is stipulated in the contract of employment that you are being, for instance, marketing, we have set this target for you quarterly. And if it is a condition of your employment, then yes, the employer has the right to terminate the agreement when you fail to meet that target. However, if there is no express provision in the contract of employment that the contract may be terminated if you fail to achieve targets, then that termination may be challenged. So once again, we insist or we reiterate the importance of the contract of employment. A well-drafted contract of employment will prevent a lot of employment contracts and a lot of employment disputes. If it is indicated clearly and the employee agrees and accepts the employment and signs the agreement, then yes, the employer has every right to terminate based on lack of performance. Now, when we say the employee has a right to challenge in any forum, it doesn't mean that that challenge might be upheld. All we are saying is that that right might accrue. But if it is stated in the contract of employment, and if the employer follows the procedure stated in the contract to terminate based on non-performance, then the employee will not have any right to challenge that termination because he was aware that if you don't perform, your contract will be terminated. Now, I'm told we have run out of time, but I see a very interesting question and I'll address that after which we will bring this presentation to a close. Yes, and it's a follow-up to the paternity leave. That's how I'm addressing it. Will I recommend paternity leave to only legally married men? The big answer is no. The big answer is no. The reason being that, you see, we are coming from a certain historical perspective where a lot of our familial relationships are not strictly per se formal. So there are many instances where a man and a woman are living together. They have 6, 7 children together, but they have not legally married. It does not mean, or the law does not say that those people do not have rights that married persons have. So if a man and a woman live together, they have a child, for all intents and purposes, the man is a husband, the woman is a wife, although they have not formalized that relationship in any way. So whatever rights a mother or a wife, whatever rights a wife will have, that woman who has lived with a man for some time will also have that right, whether or not they have formalized their union. So my recommendation is so long as the person is a father, because we, and if I say we, I mean society. Society is trying to strengthen the family bond. So everything that will go to the benefit of upholding familiar ties, we encourage. So irrespective of whether married or not, once a man has had a baby delivered for him, and you see, in most instances, not every family or not every couple can afford to have an additional help or can afford to have extra help. In many well-to-do families, they can afford to employ a nanny. In that regard, their paternity leave might not be necessary. But even that, no amount of nannies will or can substitute for the familial bond between a father and an infant. So even where the couple can afford, we still recommend the paternity leave. So the men also experience the difficulties that the women go through in bringing the little babies. So my answer to that question is no. My recommendation is that so long as the person is a father, yes, the paternity leave should be extended to them also. So in the absence of any follow-ups, or are we assuming there are no more follow-ups to the questions already asked? So please, if I may chip in, the moderator will provide our contacts, and any person who has any additional information, additional inquiries that were not addressed, or any person who wants to seek clarity on the topics that we've already touched on, may do so via email, and we'll both attend to such inquiries. In the absence of any further questions, in the absence of any follow-ups, I hand over back to the moderator to bring the presentation to a close. Thank you very much.
Thank you very much, and Abapa, for the presentation. And I hope we learned a lot today. I believe that there's a lot that has been discussed. And this clinic is the first of 4 that we'll be organizing this year. And we spoke on the rights, and then also we spoke on the sorry about that. We spoke on the rights that an employee is entitled to. We discussed the duties that the employee is entitled to in the business. We looked at leave, we looked at termination, the grounds, and all the other intricacies that goes into that. As you can see clearly on the screen, that is our contact information. You can call the first 2 numbers. They come directly to our business manager, and also one goes directly to the lawyer, and he would take his time and answer any questions that you have. Also, you can contact us through WhatsApp on the number that has been displayed, and then you can go through our website as well. I'll also use this opportunity again to say a very big thank you to Lumiere Group International for joining us in this presentation. I want to use this opportunity again to say a big thank you to Madame Giselle Dede Akwabesi. She is the CEO of Lumiere Group International. And we also say a big thank you to Mr. Charles Douglas. He's the group chairman of Lumiere Group. And Madame Selina for putting together the team for us to have this session. Next quarter, another session will come. And the recordings and the slides will also do well to make that available so that you can have a look at it, be well informed, and then live a very prosperous life in this working economy of Ghana. Thank you so much for joining us. We'll see you next time. Have a very great weekend. Stay blessed and make sure to abide by the law. Yes, that is very important. God bless you. Take care. Bye.